It's December 26th, 2025. That's right. It's Boxing Day, ladies and gentlemen, and this is the Court Gallery. Well, ladies and gentlemen, it is the day after Christmas. I hope everybody had a wonderful holiday. There are a lot of people out there whose holidays were probably fairly substandard, and they're still going through a few things. And today, we're going to meet quite a few of those people. We're going to start off in... oh my lord, I forgot. Royal Oak, Michigan, ladies and gentlemen, with Magistrate Banky. She works at the District 44th, and she had quite a few cases today that I thought were interesting. I hope you'll find them interesting also. Then we're going to quickly move from Royal Oak, Michigan, back into Thurston County, Washington. Olympia, ladies and gentlemen. How can you stay away from Olympia, especially when we have a small claims calendar to deal with? We're going to wrap things up in only a Simpson kind of way with the Friday Landlord Tenant Simpson docket. Ladies and gentlemen, it was a unique one. I loved every second of it. I put together a little compilation of some of my favorite moments from the whole docket today. Court was slim pickings, guys, because, you know, it's the day after Christmas. But we got you. I got something good set up for you, and it all starts right now.
Yes. On the case of 2502023, this is the state of Michigan versus Lauren Kelly Jordan. Your appearances, please.
Good morning, Your Honor. Bob Spencer on behalf of the people.
Morning, Your Honor. Kathleen Solomon on behalf of Ms. Jordan.
Okay. This is the date and time set for the PCC. I have a preliminary matter that I would like to address, please. It's been brought to my attention that an amended complaint / general information has been filed and signed by the magistrate in this case, and that the defendant needs to be arraigned on the amended complaint. So the court has before it an amended complaint / general information wherein it is alleged that the defendant, Ms. Jordan, did contrary to law on or about December 13, 2025, did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance of cocaine, contrary to MCL 333.74032A5. This is being charged as a 4-year felony and or $25,000, commonly known as possession of cocaine, that being a controlled substance less than 25 grams. Counsel, on behalf of the defendant, do you acknowledge the reading of the amended charge?
I do, Your Honor.
Okay. And on this, how does your client plead?
Not guilty.
Okay. One second. I'm just catching up on the ROA.
Your Honor, I'm looking at her original complaint, and I don't
The original complaint was 25 grams or more, but less than 50 grams. And I think it cited an improper a different
Okay, I
statute.
see it. You're right. That's what I thought too. They cited a 4 and it should be 5. Thank you.
Okay, so we
Yeah.
have the defendants being arraigned on the amended charge. Defendant pleads not guilty, right?
Correct.
Okay, and a not guilty plea shall enter on that. And bond and bond conditions continue. Does that suffice for the arraignment on the amended charge, or is there anything further requested or required of the court on behalf of the arraignment?
Not on
Nothing.
behalf of Ms. Jordan.
Nothing
Okay.
from the people, Your Honor.
Okay, so let's move on to the PCC. How would you like to proceed today on that? First, let's hear from the people.
Your Honor, I haven't had a chance to speak to opposing counsel on this matter yet. I'm not sure if a resolution can be reached, but I'd be interested in that opportunity if she would be.
That would be great.
Okay, would you like to go in a breakout room?
Yes, I guess. Yes.
Yes, thank you.
Or I heard some chatter before I called the case that someone wanted an adjournment. Did I hear that? No, I'm sorry, that was on the next case. Okay, let me put you in a breakout room.
Thank
Thank
you, Your
you.
Honor. Good morning, Your Honor. We're back.
Okay, thank you. Well, how are we proceeding today with the PCC counsel? Is her attorney back? I don't think so. 1 second.
Yeah, she's still sitting in there.
I
Okay.
tried it before. Okay, here we go. Okay, so we're still on the same case of 2502023. This is the state of Michigan versus Lauren Jordan, and we held the arraignment on the amended charges. Counsel, you've had an opportunity to speak. How are we proceeding today with the PCC, please?
Your Honor, could I speak to my client in a breakout room?
No worries.
Thank you. We're going to end up adjourning this, but I want to talk to my client.
Okay, no worries. Let's go to, can you guys go back? Let me see. Let's try room 3. This is like ringer, Kathleen. How about room 3? Thanks.
Thank you.
Okay, still on case 2502023, Miss State of Michigan versus Jordan. Okay, is Miss Jordan back? There's a lot of logistics.
Yeah,
We're
really.
in, we're out, we stop, we start, we go, no go. Okay, Miss Jordan's here. Attorney Solomon is here. Mr. Spencer's here on behalf of the people. What are we doing today with respect to the PCC, please?
Your Honor, we're going to ask the court to adjourn it because I think we can reach a resolution at the district court level.
Okay. Any objection from the people?
No objection from the people, Your Honor.
Okay, so we'll set this matter for a second PCC. And that will be a date after 21 days. She was arraigned on the 15th.
She was arraigned today.
Oh, you're right. So on the amended charge. I don't know when we're going to set this. 21
But
days. Okay.
she can waive the 21 days. I discussed that with her too, in case that happened.
Okay. Why don't we take the waiver, because I'm not sure when it will be set.
Okay.
Okay. So where's Miss Jordan? Will you please raise your right hand, ma'am? Do you swear or affirm that the testimony you're about to give is true?
Yes.
Okay. Counsel Solomon, will you please do your client on the waiver of the 21 days, please?
Okay, Ms. Jordan, I had an opportunity to talk to you in a breakout room, and I explained to you that you have the right to have a preliminary examination within 21 days. And that's not waiving the preliminary exam today, the waiver. You're just waiving the time to have it, correct?
Yes.
And you're voluntarily waiving that time period of 21 days, correct?
Yes. Yes.
Any questions from the people?
No, Your Honor.
Okay, the court finds that based upon the testimony and the questioning of defense counsel that the defendant knowingly, voluntarily, and intentionally waives the 21-day requirement in which the preliminary exam can be held. It may be that you'll still be within the 21 days, but I'm not sure on the scheduling. So I appreciate counsel taking care of that. The 21 days is waived, and we'll set this matter for a second PCC in front of Judge Meineke. Is there anything further requested or required of the court at this time on behalf of Miss Jordan? On behalf of the people first.
Nothing from the people, Your Honor.
Okay, and counsel.
Nothing more. I have the discovery, all of it.
Okay, you do have the discovery
Yes,
already.
I do.
Okay. All right. Thank you so much. This concludes the PCC. Ms. Jordan, thank you for your patience this morning and appearing. Good luck to you in the new year, ma'am.
Thank you.
And also to you, counsel.
Thank you. Have a good day.
Okay, calling the case number of 2101480. This is the City of Royal Oak versus Ariana Allen. Your appearances, please.
Thank you, Your Honor. John, I got appearing on behalf of Ariana Allen. Judge, Miss Allen and I are both here via Zoom. Miss Allen, as you know, is next door at the Royal Oak Police Department lockup. I did talk to her about why she's here. There's a bench warrant for her failure to appear. I believe it was about a year ago, December of 2024, and a bench warrant was issued. So she's in the Operation Drive program, as the court is aware, and I just at this point would respectfully request the court recall that bench warrant so we may move forward today.
Okay, the court will recall and set aside the bench warrant. Yes, this litigant is in Operation Drive. She failed to appear in or around April 2025.
It was this year. Okay, good.
Mhm.
So,
A
Judge,
sentence review on April 10th, 2025. I know
understood.
she was making good progress.
She moved, and I don't know if that's
okay.
why she got a different phone number as well. So unfortunately, she didn't alert us of the changes and not able to get a hold of her. So this program kind of fell by the wayside as she's been working as a nurse at Sinai Grace Hospital.
Is she on Normandy Street now?
She is on a different address, if I may give that to you.
Okay, go ahead. All right. And then did she change her phone number?
She did, Judge. It's
Okay, go ahead. All right. What about bond and bond conditions?
She needs to appear, Judge. She needs to get her license. That's not been achieved. As the court is aware, that's our only goal. I reminded her of that. I think she understands that. I know she wants to get her license back. I'd ask the court respectfully. She does want to re-engage with the program. Everybody here is a champion of the program. And I want her to believe that too once we get her a license. And I think we can do that pretty quickly for her. So I'm asking the court respectfully for a personal bond. And I told her that she's going to get a mailing as to the next date and that one of the attorneys, either I or Ms. Chappelli, will be bothering her via text and phone calls prior to that hearing.
Ma'am, do you work?
Yes.
What do you do?
I'm a registered nurse at Sinai Grace Emergency Department.
In the what department, please?
Emergency.
Oh, okay. That's a hard job.
Yes.
Yes.
How long have you lived at the Farmington Hills address?
For about a year.
Okay. How long have you held your job?
I've been a nurse for 5 years, but I just started at Sinai Grace on December 9th.
Okay.
So about a year.
Fortunately, she's missing work. One of the collateral effects, I guess.
I know. Okay, so I'm just reviewing that. She came a lot in the beginning. And then she had an FTA at this. Were you making progress in Operation Drive? Was it giving you any benefit?
Got my license. And then I got pulled over like one time and they suspended it for like a whole year.
Will we be able to help her, Mr. Anga?
I believe so, Judge.
Okay. The court is setting a $2,500 cash surety. I'm sorry, $2,500 personal bond
Thank you.
with conditions. Okay, this may be, I'm exercising my judgment here based upon what Mr. Angot feels about your success in the program. and that he has emphasized to you that the program only works if you appear and don't default. So, you know, we always say there's no get out of jail free card, but in this instance, I'm letting you release on your personal bond. I hope you don't make a fool of me, ma'am. I hope I have read your character correctly and that you will appear in this case. You don't appear again, you're going to have to post money or bond will be denied and you'll be in custody until the matter's resolved. So you can make a choice and allow us to help you in Operation Drive, or you can just continue this cycle and you and I will keep meeting again and again and again. So the bond is $2,500 personal bond. No money's due at this time for your release. You have to personally appear, whether by Zoom like you're appearing today or in person, as ordered by the court for all court events. If you're in Operation Drive, there's a lot of sentence reviews, and this bond condition requires that you attend them all. Okay, we don't pick and choose. When we want to come to court, you have to come to all of them until the case is concluded. You have to abide by any judgment, enter in this case, surrender, serve any sentence imposed. Do not commit any crime while released. Do not drive without a valid license or permit. You have to immediately notify the court in writing of any change of address from Gateway Drive South or the phone number ending in 8024. And we'll set this matter for sentence review in Operation Drive, correct, Mr. Angott?
Yes, Your Honor.
And please avail yourself of the opportunity that presents itself in this court, ma'am. Because not all courts have them and not all of them work hard to try to get you a license like this court does. So if you will allow us to help you, I believe you'll be in a better place at the end of this case. Is there anything further requested or required on behalf of Ms. Allen, counsel?
Judge, I appreciate the encouragement you have offered, Ms. Allen, and I think you've covered everything. So thank you.
Okay, thank you, Ms. Allen. You may leave. Okay, calling. Are we ready, Mr. Angott?
Ready, Your Honor.
Okay, calling the case number of 25R02087. This is the City of Royal Oak versus Omari Wesley Baker. Your appearances, please.
Thank you, Your Honor. John Angott appearing on behalf of Omari Wesley Baker. Judge, as you know, that Mr. Baker is in the lockup next door at the Royal Oak Police Department. I did advise Mr. Baker of the charges against him. We spoke about the possible penalties as well. I believe he understands both aspects of that. We also talked about his constitutional trial rights going forward. I believe he understands those rights as well. As such, Judge, as for this arraignment, I would ask the court respectfully to waive formal reading, and I would stand my client mute.
Okay, based upon your representations, the court will waive the formal reading. Defendant stands mute. A not guilty plea shall be entered on your behalf, sir.
Yes.
Okay, is assigned counsel requested for this gentleman?
Yes, Your Honor. He's financially unable to retain counsel.
Okay, that request is granted. Counsel shall be assigned. Sir, is the Harper Avenue in Detroit a good address for you, sir?
No, that's an old address for me.
Okay, hold on. What?
Judge,
Okay, let me look at the booking sheet to see.
He's actually been at a motel, Judge, paying on a weekly basis. And it's called the Crystal Motel. It's in Detroit on 8 Mile in Greenfield.
Okay.
And I'm sorry, I didn't get a chance to look it up because this computer.
Can you receive, is that in Detroit?
It is, Your Honor.
Okay. And are you able to receive mail there, sir?
Yes.
Okay.
My room is so.
Oh, I'm sorry, Mari, I didn't ask you that. Thank you.
Okay, thank you. And what do you have to say about bond and bond conditions, please?
Judge, I did talk to Omari about his work life. He is, in fact, in the concrete business. He's been working for the same company for about 16 to 18 months. It's a solid job for him right now. What he did indicate to me is because of the holidays, they are not working for these last week or so,
Right.
but
I was gonna say, are you temporarily laid off
Yes,
because this season?
yes, I'm temporarily laid off at the moment. I was actually in the process of filing for unemployment for the week.
Okay. All right, continue, Mr. Angott, please.
thank you, Your Honor. Judge, obviously funds are tight for him right now. The motel is not cheap. I think it's exhausting quite a bit of his available funds, but it's the place he needs to live for now, and thankfully he does have that and does have an address. So
Okay, is he on probation still, or he is?
He is. He's on probation in Highland Park. What I advised him is that eventually Highland Park is going to know of the arrest. He's obviously presumed innocent at this point, but I believe he's going to get ahead of that and report to Highland Park that the arrest did occur, and so hopefully they'll deal with it the way they do down there in Highland Park. I've not worked a criminal case there in some time, so I'm not familiar with them.
It's been a while. I used to have a big civil docket there when I was
I used to do
very young
landlord tenant
lawyer.
there.
I haven't been there in a long time.
But she's a great judge there. I know that. So I think that, he's just got to work it out. So he's got a lot going on, Judge. It's a difficult case to say, hey, can you please give him a personal bond? I have to ask for that because he has no money. We talked about friends and family and contacting somebody and said, I just don't have any but contact. And I paid my rent this week. I don't have anything. So any bond is $1 billion bond to him. I'm going to leave it to your discretion.
I know.
But I'm asking because I had a good conversation with Omari.
What's the most that you could maybe call and post and find?
Be honest with you, I
appreciate that. I want you to be honest.
I literally just paid $300 a week at my motel, and last like a week already, I was kind of short, so I just borrowed money from my brother, the only person who I probably could have borrowed money from. And,
Tell me a little bit about your connections with family and friends in the community.
Well, all I mainly do is work. I have a couple brothers. My mom, she's in hospice right now.
I'm sorry to hear that.
Thank you.
Where does your mom live?
She just moved. She was at what was it in
what city?
She lives, it's right past Telegraph and like
And how about your brothers? How old are they?
One of my brothers, he's 29, and the other brother is 30.
How old are you?
I'm 28. I turned 29 next month.
Who's the person that you're closest with?
My oldest brother, Perry Baker.
Baker?
He's the only one that really like lives in the city for real. Like my other brother is a truck driver, so he like drives around a lot. But he's the only brother who I can like kind of depend on if it came down to money. But like I said, I just borrowed money from him just to pay my rent.
Right.
And to be honest with you, Judge,
you're struggling right now.
I am. But
you had a bad day.
I'm gonna lose all my stuff if I am still locked up. I can get on a payment plan if possible.
Okay, well let's not go to the worst case scenario. Okay, let me ask you something. Who is this Barca woman? Is she your girlfriend, or were you on a first date?
Well, me and Kayla, we've been dating and dealing with each other for almost 2 years now.
Okay.
We was at the movies.
Right. Okay, don't say anything more. I just wanted to know the type of relationship you have with Miss Barca.
And I probably could call her to post Barca.
Okay, do you have cell phone service?
I
mean, like if you were to get released and I order you to be supervised by pretrial services, do you have the ability to call pretrial services? If I say you have to check in with them 2 times per week, do you have a phone?
Yes, I have a phone, a Verizon service. So I paid way too much for it, but it's something I need because I,
Okay, yeah, you're gonna need a phone.
yes,
Because if you're telling me that you may move out of the motel, or we're not sure where you're gonna be, the court has to be at your attorney's and the court has to be able to contact you. So that's very important. Having heard the statements made by the defendant, Mr. Angott, what type of bond conditions could you propose?
Judge, if the court would consider weekly check-ins, if not more, with pretrial services, so we can keep a tab on where he's living and what he's doing, that would be first. Of course, no violence, no negative contacts, no going back to Imagine Theater. In fact, you even keep him out of the city unless he works here.
Where does Miss Barker live? What city?
she lives in Royal Oak.
She lives in Royal Oak?
Yes, she does different things. She has another house as well, but she mainly rents a room out of a hostel at Royal.
Okay.
We was, yeah.
Do you have $20 you could post?
I have $16 in my wallet,
Okay.
and I can probably call my brother to send me 20 if possible, but
All right, the court is setting a $10,000 personal bond. No money's due at this time with the following conditions. I'm doing you a favor, sir. Okay? Because I don't want you to be homeless. But you better be sure that you follow these bond conditions to a T. Okay? To a T. You have to dot every I and cross any T. There's no wiggle room on these bond conditions. They're not a maybe, they're a shall. Do you understand that?
yes,
All right. You have to personally appear, whether by Zoom or in person, for any and all court appearances. This is a misdemeanor, so the next court appearance, if you don't violate the terms of this bond, is most likely going to be a pretrial conference. But no matter what the court appearance is titled, if it has your name on it, in this case number, you have to appear by Zoom or in person. Do you understand that?
yes,
You have to abide by any judgment entered in this case and surrender to serve any sentence imposed. Do not leave the state of Michigan without permission of this court. Do not commit any crime while released. You shall immediately notify the court in writing of any change of address or from the motel or your telephone number. If we try to call this number and it doesn't work, you're in a world of hurt. Do you understand that, sir?
yes,
Okay. You cannot use alcohol, marijuana, or any other illegal controlled substance. You shall drug test 3 times per month.
Judge,
Yes, sir.
I'm actively already drug testing twice a week,
Oh, you are? Okay.
and I've been clean for a while now, so
Okay. I don't know what happened yesterday. Hopefully drugs weren't involved.
no,
2 times, you drug test 2 times per week out of Highland Park?
yes,
Okay. So a bond condition is defendant must comply.
I usually get a sheet of my
Okay.
drug tests
With
and
all terms, that's probation, right? On Highland Park?
parole, no probation, yes,
Probation.
yes,
Okay. If I say, Mr. Angott, if I write on this bond condition, you must comply with all terms of probation out of Highland Park, how will we get the drug test? Like, how do we?
I can actively show you my drug tests.
Okay.
Judge, if he has access to them, that's probably the best way, but
Okay.
that court
So,
will participate and help or offer that information.
okay. This. Okay, this is a mess. Okay, so let's go back. You cannot use alcohol, marijuana, or any other legal controlled substance. You shall drug test as required out of Highland Park. Okay?
Yeah.
You have to report those drug test results to pretrial services. You have to check in with pretrial services 2 times per week. Okay, you're going to get a piece of paper with the phone number on it. You have to call pretrial services by Tuesday, December 30th, 2025 at 3:00 p.m. to set up your supervision. You have to report your drug test results to pretrial services. You must comply with all terms of probation out of Highland Park, including drug testing. You are not to possess or purchase a firearm or dangerous weapon. You shall not assault, harass, intimidate, beat, wound, or threaten all employees and the security of Imagine Theater, including Mr. Chowdhury, Charles Gunn, and your friend, girlfriend, Kayla Barca. You shall not have any contact, either direct, indirect, yourself, or through third parties with the same individuals. All employees and security at Imagine Theater, including Zara Chowdhury, Charles Gunn, and or Kyla Barca. You shall not have contact with Kyla, okay? I don't know if she's your girlfriend or not, but from this minute forward, until things calm down and we get a lay of the land, please don't contact her. Do you understand?
But, is it a police report on her or me with her or something?
Something just came up that you were calling out her name at the theater.
Oh, yeah.
Okay. Okay, don't say anything more. That's why there's something in the report about her. So until we got this situated, you're not to have contact with her. Don't go to Imagine Theater in Royal Oak at 200 North Main Street. And the bond is 10,000 personal. Okay, you messed this up, sir. You're in a world of hurt, and that bond is going to convert to even a greater financial bond. We're going to set this matter for a pretrial. The notice to appear to the motel, room 37. Does the motel face 8 Mile or does it face Greenfield? Do you know?
It sits behind a gas station and
Okay.
so it's not like right there off of 8 Mile and Greenfield.
Okay, let me just Google it to make sure that you and I are on the same page. Okay. I would like to set you up for success.
Thank you.
You know how you can thank me? You can complete this case and turn your life around. Mine's not working. Okay, is it at 20490 Greenfield Road in Detroit?
Yes.
And it has nightly prices. So that is it. 20490. Okay, so we got a phone number, we got an address. You're going to have an attorney. This was a long arraignment. Are any of the conditions I stated unclear to you, sir? Like what I've said, it was a little choppy. Anything you want me to clarify for you?
Pretty much understand what I have to
You
do.
don't have to post any money to get out. When you are released, you can't go to Imagine Theater. You can't have any contact with the security team there and or any employees. And you can't have any contact with Kayla.
Okay.
Okay? You can't threaten, assault, beat, wound, intimidate any of those people. Stay clear of Imagine Theater for your own good, please. You can't possess a firearm. And you have to contact pretrial services by Tuesday at 3 p.m. to set up your supervision. You're going to call in there 2 times a week. You're going to get a piece of paper like this that has the phone number on it, okay, and the paperwork from the jail. All right, so to recap, we held the arraignment. Defendant stands mute, not guilty plea. We waived the formal reading, assigned counsel. We have address, contact information. The bond is 10,000 personal with the whole litany of conditions that this gentleman's going to abide by. We're going to set this matter for a pretrial and he will have assigned counsel. Is there anything further requested or required on behalf of Mr. Omari, counsel?
Judge, may I address him, please?
Yes. Yeah. Oh, you want to
Omari,
go to the breakout room?
no, I just want to talk to him right
Okay.
here. Omari, I just want to say this. What you just received, this bond, is a better gift than anything you've gotten probably in your life. It's the best gift I've seen this year. You've got to make use of that, okay? Like the judge said, I was going to say the same thing. You're in a great court. If you have to be in court, this is a point where you got to decide what road you want to go down, turn your life around. Pick the right road, show up, get this thing done, okay? We'll get a good attorney for you, and he or she will take you the rest of the way.
Okay.
All right.
Every attorney that I've met here that I've come across is very confident, and I trust that you're in very good hands. Okay. I know that you have a better person inside of you, sir. I believe in you.
that.
Okay. You
Yeah.
take care of yourself. All right.
Yes.
All right. This concludes the arraignment. You may leave the Zoom.
Thank you, Your
Thank you,
Honor.
Mr. Angot. Take care.
Okay, thank you.
Okay, so Ms., is it Lappelle? How do I say your last name?
Lappelle, Your Honor.
Lappelle, could you raise your right hand, please? And then do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
So how is it you're asking for a judgment in the amount of $4,200?
I initially am asking for $4,200, which is the $3,600 I paid as a first installment in a conditional agreement, a two-part conditional agreement. $66 for the service cost to serve the defendant, and then 4 days worth of work I missed over the course of this incident and dealing with this. I am, however, at the end of the day, truly only seeking my deposit back, my deposit in the court fees. And this is something I did relay.
Okay. So tell me what happened here. Again, you wouldn't be entitled to the lost work anyway. So $3,600, where are we at? What happened?
So, Your Honor, this action arises from the defendant's breach of a two-part agreement for an RV that she had listed on Facebook Marketplace. The defendant's misrepresentation regarding the RV's condition and legal ownership, and her refusal to return a $3,600 deposit after the transaction failed due to the RV being unsafe, non-roadworthy, and incapable of lawful transfer. This matter concerns a clear breach of contract and bad faith conduct by the defendant, and it has resulted in financial harm to myself, the plaintiff.
So what happened? Did you?
So I contacted the defendant in hopes to purchase her RV. I had been looking for housing. I was getting very close to, my housing issue was running out, and I was getting very close to homelessness. I initially asked her right off the bat if she would take a lower amount. She had her RV listed at $4,500. I asked her if she would take $3,600, and she did immediately say yes. She did say she was looking to get closer to $4,000. And me being in the position that I was in, which was an incredibly, incredibly bad, very strained situation, wanted to also try to help an individual out as well. I was asking if she would be willing to do something a bit unorthodox where we could do a two-part arrangement. And I wanted to specifically do this so that I could have time to check over whatever vehicle, whether it was her or anyone else, that I could check over the vehicle and make sure it was safe. As the vehicle in question, whichever it was that I was going to be purchasing, was going to be my residence. Not only my residence, but my transportation. So this was going to have to last me years. It needed to be safe. It needed to be reliable. These were my main concerns. I took it to have it diagnosed. It came back less than 24 hours later with over $7,000 worth of damage, major mechanical failures that the defendant did not remotely allude to. She continued to double down that the vehicle was safe, even after a diagnostic report conclusively shows that it's not safe to drive. The shop also highly recommended that it is not driven, that it was not safe. So I then told the defendant that she had to move it at her own expense because I was not going to risk my safety. I then immediately demanded the return of my deposit because I was no longer going to continue on with the agreement, as the basis for why I entered the agreement with her and what she represented was not factual nor true, therefore nullified our agreement. She then told me that she was unable to do that because she spent the money on several big bills she already had and was unable to return the deposit money. I then told her that that didn't negate her from needing to return the deposit money, especially since the deal was not complete. Our deal was going to be complete on Friday when I gave her the remaining balance of our second part of our deal, where she would then transfer over the title. At that point, our deal would be complete. So at the time that she spent the deposit money, I was not in legal possession of the vehicle. I did not have the title. It was not in my name. And she still retains that. So she
Hang on
has
just a second. Stop for a second. I have a question. So where is it now? Where's the
She
RV
has
now?
the RV. She has it.
And the title's in her name?
Correct.
Still?
The title's in her name, which she transferred into her name after we entered this agreement. So at the time we entered this agreement, she was not the legal owner of this RV.
Got it. Ms. Sager?
Yes, thank you.
Raise your right hand, please. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
What's your position on all of this?
Miss Lappelle asked, was interested in purchasing my RV. Like she said, I would have it listed for $4,500, and she asked if I would take 36, and I said I said I'm hoping to get 4,000. You can see that in our messages.
I did see that.
Yes, and she said I only have 36 now, but I'd be willing to meet you at 4,000 if you can wait until I get my next paycheck on Friday, as she just stated that she would have the remaining 400 on Friday. I said that was okay, and I said I'd like to hold on to the title until you're able to give me the remaining $400. Your Honor, the first I heard of this being a deposit contingent on a mechanical review was after she was already asking to give the RV back and get her money back. As you can see in our handwritten purchase agreement, which I submitted and she also submitted, it's Exhibit 1 in my table of contents, and it's the last page 69 of her evidence. There's nothing listed or mentioned about $3,600 as a deposit, which is a very large amount for a deposit on a $4,000 purchase. That's an odd amount to give as a deposit. But it doesn't mention anything about this money's being held as a deposit contingent on mechanical review.
Did you own she's telling me that at the time she gave you that wasn't even in your name. Is that accurate?
I did own it. I have a purchase agreement that shows that that it was mine a year before. I'm going through a very awful divorce, and everything that we own, everything that we own was being held in a different place. And so the reason it shows it being titled in my name only a few days after our purchase agreement is because when titles in Washington State are issued, they're a Bob and Joe or Bob or Joe. And if it's Bob and Joe, both people have to legally sign and participate in the sale. If it's Bob or Joe on the title, only one person has to be there to facilitate the sale. So I had to transfer it out of Bob and Joe from my marriage.
I see. To your separate property.
Yes,
No,
so that's why the title shows a new title in my name 3 days after the purchase. Her and I purchase agreement. It wasn't that it wasn't mine to sell. I had to transfer it so that through our legal process and our divorce, it showed it was coming just from me.
And you have the RV still in your name and possession?
No, sir. I gave the RV away. I held on to it and repeatedly. There's a family here in Olympia, Washington. I guess we're both in Olympia. There's a family here that didn't have housing, and I had given it to them for the winter. In October, from August through October, when our last court date was, I repeatedly offered it back to Destiny. It's in great shape. It's beautiful on the inside. It's completely livable. I can walk you through the inspection.
Okay, so hang on just a minute. You know, one thing that I should have done but didn't do, and that is don't interrupt the other party. She didn't interrupt you, Ms. Lappelle. I'd offer her the same courtesy. You'll get an opportunity to respond.
Apologies.
But go ahead, Ms. Sager. You can continue.
Yeah, I held it for her through October when our last court date was. And at that time, I was paying storage fees for it that whole time. And I held it in the hopes that she would take it back. It's a great vehicle. If I hadn't needed the money to take care of my family myself, I would have kept it. And I held it through October, and I did let Judge Buckley know in October that, Your Honor, I won't be able to keep holding it until the end of December. I can't afford the storage fees, but I was happy and available to still let Destiny have it. I would have driven it to wherever she needed it. I would have helped her sell it to recoup the money. But I was not able to keep paying the storage fees for another. She asked for a continuance, and Judge Buckley granted that until today, and I wasn't able to hold on to it for her. And so it was not a deposit. As you can see in our contract, it was for the amount of $4,000, as is. 36 paid in cash on the 3rd, 400 to be paid by Friday, to be paid by that Friday when she said she got her the air was low, and I recommended she bring it to Busy Bee Automotive, which was down the road from my house. She test drove it for almost an hour. I would like to say that as well. She brought it to Busy Bee. They asked if she wanted a full diagnostic, and she said yes, and they kept it overnight, and they did that. And in the diagnostic, what they gave her was their recommendations of work that needed to be done or could be done. So it was $7,000. As you know, mechanics do that. They'll say, you should do all these things, but none of that was necessary for it to be driven, for it to be lived in. It was meticulously owned by the same couple. It was beautiful inside before I got it. Everything worked, shower, toilets, all the beds, microwave. It had a larger stove than normal. And mechanically, there were things I let her know. It's almost a 40-year-old RV. I had let her know there are mechanical things you'll want to do. It's past its life for road tripping across the country, but I was still taking my kids on trips with it. She sent me back a message with all these things that they said had to be done for it to be safely driven. And I explained to her that I disagree with all those things needing to be done. She said there was no sway bar, which there was. She said, you can see in her messages, all these things she said, which weren't actually, yes, the brakes needed to be replaced. Yes, there was rusting on the wheel bearings. But she said that it needed a new radiator, that it couldn't be driven. It was only leaking radiator fluid. I didn't know. The shop told me it was leaking radiator fluid because of one seal that needed to be replaced. It had just dried out. It wasn't that the whole radiator needed to be replaced like she was saying. And if you look in their diagnostic report under radiator fan and assembly, it says findings none, because they didn't find that it needed to be replaced like she was telling me. She told me she couldn't even take it on the freeway to get it home and live in because it had no sway bar, but that's not true. You can see pictures of the sway bar in the diagnostic report. So I gave her all the information that I had about the RV. She test drove it for an hour. She was really enthusiastic about having it. And I am understanding of this process enough that had this been a deposit contingent on mechanical review, as she's asserting now, I would have written that in our contract. I think that would have been in the contract, but this was a $3,600 purchase, as is. She was going to pay me the remaining $400 when she got her next paycheck.
And Ms. Lappelle, you had your hand up, and I know you wanted to say something. Go ahead.
Yes. You can also clearly see in the messages and the exchanges that I did say that I would give her the remaining $400 as long as everything was good. So I had a pretty bare bones requirement as far as what I needed. She is right. The inside was kept very meticulous. That was great. Whether it wasn't or not, that was not going to sway my opinion. I'm a very, very independent and mechanically inclined individual. I can repair a lot of things, as well as mechanical issues. However, these particular mechanical issues, which are major malfunctioning issues, which they did, highly recommend that it does not leave for safety reasons, which is precisely why I made sure that the defendant knew that she was going to need to move it at her expense. I would not risk my safety again. The radiator being blown requires a new radiator. So these are all recommendations, because it's a recommendation that if you want a safe vehicle, this is what you need to do. They're not going to tell you, no shop can tell you, you have to do this. It is always going to be a recommendation. This is a shop that she specifically recommended. She said, I've just recently been to them. They're new in town. They're great. Highly recommend them. I went there as soon as I responded to her and let her know what the diagnostic findings were, what the shop said. She said, I don't think that you should trust them. They're new in town. I think you should go somewhere else for a second opinion. So she instantly turned around her opinion on that. This is the most thorough diagnostic report I have ever received anywhere. I thoroughly trust these guys. They were incredibly kind. They were very transparent. They were very cooperative all the way through. They were able to get me that diagnostic report not even 24 hours later. I dropped it off with them Sunday, August 3rd at 2 p.m. And they got back to me, I think it was like 11 or noon the following day. And I immediately contacted the defendant. So it wasn't even 24 hours later. And that's when she told me that she had spent that money. So regardless if she's unclear on it being a deposit, which in a two-part agreement, a first installment in a two-part payment agreement is a deposit, from what I'm understanding and what I'm learning, whether it was explicitly stated as a deposit, it does also show in my messages that I, again, reiterate, as long as everything is okay, as long as this is all good, I will then at Friday give you the remaining $400, which is why I chose to not do that, which is why I chose to back out, because everything was not okay. They recommended the work that was about $7,000 worth of work. That already puts me in the hole. I took out a $2,000 loan out of this $3,600 to try to buy something. So I'm already in the hole for that too. I still have to pay that $2,000 loan back. She's still in retention of my deposit and the RV. I'm not sure why the defendant feels that even if she's misunderstanding if this was a deposit or not, why she still felt that there was legal basis or right for her to spend that money before the completion of the agreement. Like until Friday, when I gave her that $400 and she handed me the title, our deal was not complete. It was still in a partial agreement. Whether she had big bills or not, that money should have been saved to be spent until after and it was finalized and completed. That does not negate her from needing to return that money when there was no exchange of goods.
There was.
There was not. Also, I'm
So
sorry.
hang on,
I'm sorry.
Ms. Lappelle, if you're done, you can stop.
No, I'm
and
not
then
done.
Ms.
I'm
Sager,
not, because
okay.
I do
Okay, keep
specifically
going.
remember something I wanted to respond to. And in regards to that, she brought up last court hearing that she would gladly give it back to me. She also continuously, in her giving back, she wants me to pay the remaining $400 in order to give it to me. So she's not giving it to me. She still wants me to pay for it. I'm still buying it, and I don't want to buy it. Like, I don't feel like I should be coerced into buying something that is mechanically not sound, that I was not. I was very clear. I came very thorough, very, very prepared. And I may have left emotional because of an issue with my mom, but that does not mean or justify any legal basis for her spending money that was not legally hers yet to spend until a title was transferred.
So Ms. Sager, I'll give you the final word here, and then I'll be ready to rule.
I would have been, had she wanted to take it to a shop before she purchased it, that would have been just fine with me. I loved this RV. This signified like my freedom from my divorce. My kids and I traveled in it all summer. It was a great RV. I wish I could have kept it. I think she was getting a really great deal. There is nothing in the diagnostic report that shows it couldn't be driven. I drove with it all summer. She told me I was lying. I sent her a video of me driving it with my kids just a month before. She said I was lying because my hair was different, but I'm going through a divorce and my hair has been 4 different things in 1 year because that's what I have control over. It was long and platinum blonde when she bought it. It's short brown now. I drove with it with my kids and their friends to the beach and the coast and camping all summer. It was a great RV. She bought it as is. There's nothing in the diagnostic report that shows it was undrivable or unlivable. She gave me the $3,600 and would have given me the full $4,000 that day. She said had she had it, but she needed to wait for her next paycheck. I'm a single mom now with a full mortgage that I can't afford. The day I was already late. The day that she gave me the money, I immediately went and paid my mortgage and all of my bills, my water bill. I offered to give her the RV back multiple times. I offered to help her sell it, to help her recoup her cost. She could have driven it to wherever she needed to and fully lived in it or resold it. It was in amazing condition. You can see in the pictures, I kept like tire covers on it. It was, you know, besides the work in the diagnostic report that they recommend, like 2 bricks driving on and then 1 seal for the radiator. And the other work that you can see, which just comes along with a 40-year-old RV. It was completely drivable and livable. And I'm really sorry this happened. But we did have a contract and we did sign it as is. And
how did the RV get from the place that was being inspected back to your place, ma'am, Ms. Sager?
I went and picked it up. She told her in the messages you can see, they told her there's a fee beyond a certain number of days if you leave it here. She lives out of town, and they told me I'd be responsible for that daily fee if I.
How do we get back to the other session?
And then she told me you need to go pick it up. And so I went and picked it up from the shop.
All right. So here's where I'm at there, ma'am. You know, basically what happened, as far as I can tell, you had reached to, I think this was through Facebook Marketplace, if I'm not, or one of the, and where this was listed for sale was an RV, apparently an old RV listed for around $4,000. Apparently some sort of agreement was reached, but was never completed. Ms. Lappelle took the RV, which is quite reasonable, to get it inspected to find out if what the condition of was that of the thing that she wanted to buy. Once she found that out, lost interest in the RV, decided I don't want to buy this RV anymore. It wasn't really used. It wasn't really, title was never transferred into her name. And so the deal was never completed. Basically, it was just rescinded as far as I can tell. And then, and you know, and I recognize both of you apparently are in difficult financial straits. And I'm sorry about that for both of you. But in that she never took possession other than just to get it inspected. Title was never transferred. You know, I find that the deal was never completed.
Your Honor,
it was given to somebody else. Hang on, ma'am. Just let me finish, please. And so, you know, basically, what to decide in favor of you, Ms. Sager, it means that basically you would get, you know, she's out $3,600 and gets nothing in return, and that's kind of where she's at. So I'm going to decide in favor of the plaintiff. The deal basically went off, and a judgment will enter in the amount of $3,600 plus a $50 filing fee and $66 service fee. Total judgment amount of $3,716. You wanted to say something? Go ahead. Ms. Sager, you're back. Wait a minute. I think we're waiting for Ms. Lappelle to come back. There you go.
Hi, sorry, I panicked. I didn't know what happened.
Your Honor,
ahead,
Your Honor, I would have given her the title the day we signed the contract if she had had the full amount.
Right, I understand that, and it was never. I know that. That means it was never the full deal. Never completely went through.
But she
I mean,
refused.
so
She refused to. She refused to take. I offered her the RV back. She told me to go get it from the shop, and I said, "Come get it. Come get it. It's yours. You signed a deal." Like I offered to give it to her back.
I understand that, man.
Signed an agreement, Your Honor, and actually, I understand the way this works. I would have given her she still owned the RV. I left it on my property for months, and and then I moved it to a storage unit. And I told her, I said, "This is your RV. Come get it." And she said, "I don't want it back. I only want my money back." But she had already bought it. She had already agreed and signed the contract. And when you buy a car from a car lot and you're making halfway payments and then you decide to stop, it's not like you just get all your money back from a lot.
Okay.
Like from
So, ma'am,
this
isn't a lot. This is quite a lot different from that. And I've explained my ruling. If you disagree with this, you're free to appeal that. But that's going to be my ruling here today.
Will do. Thank you, Your Honor.
And you're free to go. Both of you are free to go. And
Thank
Ms.
you,
Lappelle,
Honor.
you can get a copy of this off the district court website, or both of you can.
Thank you. Have a great day, Your Honor.
Next is going to be Ms. Iceland, Mr. Straub. Is that you folks? Come on up here and take a seat. Okay, so who's going to speak for you folks first?
Elizabeth Iceland, Your Honor.
Okay, could you raise your right hand, please?
Yes, Your Honor.
Do you swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. So you're asking for a judgment in the amount of over, the jurisdictional limit here is 10,000. So you're asking for, but your position is apparently he owes you a lot more than that. And how is it that he owes you that amount of money?
The defendant lived in our rental for over 3 years, and during that time, he continually got further and further behind. And in the process of us trying to work with him, he ended up owing us over the $10,000 limit. I did put that on there that it was strictly for rent, utilities, and very minimum late fees, which are actually, we filed in the court, Your Honor, and it shows we kept a very detailed record of the monies that were owed.
Okay, so how much was the rents per month?
His rent, Your Honor, was $1,249. And it was reduced because it did need.
Hang on just a second. How much did he pay each month? Because it's hard. This is kind of confusing. So he would pay like $400, $900, $250, or what exactly? And so what months are missing on the rent?
Okay, if you go ahead and look in the documentation,
I
Your
have it
Honor.
up in front of me.
Okay, it's completely detailed, and even the individuals that he moved in without our knowledge, when we found out about it, they would pay part of the rent to us per the deal they made with him, and we would deduct that. So even if it was the people that he moved in, we gave him credit for any monies that were paid to us, and they were deducted from what his payment should have been during that time of the $1,249 payments. There were times, Your Honor,
so
where.
hang on just a minute.
Okay.
And when did he move out?
I found out that he had moved out on, I have a text message from him on October 15th. He hadn't given us notice prior and had even agreed in another text message that he was going to work with another individual to help get caught up on his rent.
And so your position, I see at the total, basically over this tenancy, what was due was $48,150, but he only paid $36,000, and based on missing rent or not paying as much as he should have, basically.
Correct. And all you'll see there, Your Honor, every time someone else paid, one of the people that he'd moved in, we gave him full credit for that, and even took money off.
And I see that where you just paid different. Okay.
Correct.
All right. So let me hear from Mr. Arneson.
Hello, Your Honor.
Hi there. Could you raise your right hand, please?
Yes, Your Honor.
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
So help me God.
You put your hand down. What's your position on what I just heard? Basically, that you were not paying full rent and other things to the tune of, according to their records, nearly 11,700.
Your Honor, when would be the appropriate time to call for a continuation so that I may gather more information?
That was about an hour and 15 minutes ago.
Okay, because we went to mediation and I tried to resolve the issue and they didn't agree.
Right. That's
so
why we're in trial. That's what happens when you don't agree in mediation, is you go to trial.
Okay. So I have no evidence gathered for this case.
Well, what's your position on I mean, sometimes there isn't any evidence. Sometimes what they're saying is, one side is saying, is completely true. I mean, do you have evidence that you did pay the things that they're saying you did not pay?
Well,
That's
there's
the
reasons
issue,
for
is
me
whether
not
you
paying.
paid or you didn't.
Yes. Right, Your Honor. No, I did not.
You did not pay?
No. And there's reasons for it.
So what would you need a continuance for if you basically were kind of in agreement on what the facts are?
Well, we're in agreement to the rent. The agreements that we made are different than the terms that were originally outlined in our paperwork.
What's your position as the tell me about that. How has that changed? Basically, from what I'm hearing is basically this was just a rental agreement. You weren't up to date on rents, and
right.
They want to get a judgment in that amount.
Right.
You're saying, yeah,
and
I did rent, but I expect I'm going to hear something, a reason why you shouldn't have had to pay that. And then when I hear that, I'll ask them what their response is to it.
Right.
So
I moved in and there were a few problems, of course, between, job loss, my car breaking down, several things like that did happen through the period of time that I was renting from them. And they did work with me at first, and help. I told them, when I do get money, I'll give it to you. And I would, we worked out. Basically, when I had money, I would give it to them. And it wasn't everything all at once, but I would catch up and then I'd fall behind. And it was just difficult, basically, to get back and forth to society from where we lived. That's neither here nor there. I knew that I was moving out in the middle of nowhere, and I did fall behind quite a bit. There were just things that needed to be done. I had to buy a new fridge because one went out, and all my food went bad, so I had to buy more food. That happened, so they fixed it, but the floor was slanted, so the new fridge that they brought in, the motor went out because it was stressed, and then my food went bad again. Just stuff like this would always be happening there. I swore that the place was cursed, but that's neither here nor there again. But I could not get records of my payments from these guys. I kept on asking them. I also asked them to take care of the black mold in the house, and they said I could take care of it, but that I'm not an expert at that. I don't know exactly how to get rid of it all the way. And then moving people in, I did to help me pay rent. And they did agree, but this was all verbal. I should have had it written down so that we could have it legalized instead of word of mouth. But they did agree to both people being there. Otherwise, I imagine I would have been relinquished from my lease and kicked out because I broke lease. But they did agree. They did take payment from them. And then later on, they moved in somebody I did not agree to. We had problems with the leasees that I had helped move in due to drug usage and going crazy and grabbing knives. I had to call the police. I wasn't comfortable living there anymore. They wouldn't move them out. And then they moved in another guy recently, and they basically forced my things out without him being on the lease or me agreeing to him, and damaged my property and just piled it up and threw it in one room. That's when I decided I had had enough. Defamation, talking to people that had no business knowing any of my information, and then spreading lies about me, harassing me repeatedly when I said that I would pay them when I had money, but they would show up when unannounced, and basically breaking lease many different times, the renter's agreement. So I don't feel like I owe all of the money. I do believe I owe them money, but not the full amount that they're asking for due to the hardships that I've had to go through just dealing with living there. That's why I moved out. I'm homeless right now currently because it's a better situation to be homeless rather than live there with the things that I was going through. So I did move out due to this other individual moving himself in and forcefully moving my things out of the places that I was still renting. They informed me that I would still be paying the same amount and that these people would be taking and occupying space that I had originally rented. And that was not our agreement. So I decided to abort mission and leave. And I said, if you want to come after me in court, that's fine, but we can work something out once I get back on my feet. But they decided to take it to court. So here we are, sir. And I still don't know how much I owe because they wouldn't give me the records, but now they have them. So,
well, there were the exhibits that were submitted, and then they have documentation of all the thing. And according to them, you're about 11,000 into the hole. And so, but they're limited on what they can get here in small claims. The judgment would only be in 10,000.
I understand that, Your Honor. On paper, yes, that's what it looks like.
Yeah. So, ma'am, I'll come back to you. What's your response to what you heard?
Again, Your Honor, this case is not about any issues as far as any damage that we might have found after we went to look at the rental approximately the 18th of October. This is strictly monies that he owed us for rent, water, garbage that he never put in his name during the 3 years he was there, and very minimal late fees that we charged him. He did make several statements in regards to other people being there. We never rented to anyone except for him. He did move other tenants in, including his drug addicted sister, who was underneath the rental smoking drugs and stuff. But anyway, we never agreed to anyone else being moved in until after he'd already done it. Apparently, they were paying him money for rent. So essentially he sublet without our knowledge. The deal we made was that they would pay rent to us and we would deduct it from his monthly fee, giving him all of the credit. I do have on my phone, I do have text messages where on the 15th of October, he said that he had moved out. It was only after that we went to the rental. I do have a message on approximately the 7th of October on my phone, which I can provide, where he said, yeah, he was going to work a deal out with this gentleman by the name of Banky, so that Banky could help him to pay the monies that he owed towards the rent. We never moved anyone else in. The situations regarding the other people that were there, I don't know exactly what happened, but again, we never agreed, and we told him, then you need to move them out. We never put them on the lease in the first place. It's your responsibility. You're the one that brought him into the rental. And unfortunately, he had changed every single one of the locks. We couldn't have access for, over a year. We tried to get access. He would never answer the door and let us in. We did not even get access until I believe it was approximately the 18th or 19th of, and I apologize, Your Honor, I thought I had turned that off. I apologize. Turn my phone off, please. And another thing is, if you look at the addendum to the lease, which I did provide, he was provided with that. He numerous times was provided with the itemized statement that we kept current month to month as to any payments that were made by him or the other people that he sublet to. It clearly says in the addendum to the lease, we were reducing the rent. We reduced it approximately $200 a month because he was going to be, washing the windows and, repainting. And during this over 3-year time, even though we never raised the rent to the original amount, he only painted 1 bedroom. That's the only thing that ever got done. And again, I've got documentation in regards to all the damage that was done when we actually took possession of the unit, approximately the 18th of October. But that's not even the issue today. The issue is the monies that he owes for
Unpaid
back
rent and utilities.
Correct,
Right.
Your Honor. It has nothing to do with any of the damage that we have documentation to. That would be a separate matter if we were to proceed.
So, Mr. Arneson, I'll give you the final word here.
Yes, Your Honor. I scraped popcorn ceiling halfway through the whole entire house. Also painted two of the bedrooms more than once because of these roommates that they did agree to. They actually knew one personally for ever since she was a little girl in that town. This is why I want to subpoena my cell phone records, because what they agreed to and what they're saying here in court are 2 different things. Also, talking about damage of property, I left that place pristine compared to how I got it. The back door was damaged by a neighbor. That's all that I can imagine that they're talking about in all reality. But moving this Benji guy into the house was completely their decision. They got together with the roommate that is still there, but they're kicking out also, and conspired to get me moved out by force before they went this legal route. And Benji came and literally took the lock off the door due to another rentee from another property coming in and doing so, which was completely illegal, but that's okay. The cops told me that I should take this to court due to them breaking the lease in several different instances. I had just had enough after that. I thought we had worked out something, and I was going to pay them as soon as I had this job that I have right now. I was going to start making payments again, even after I had moved out. But when they said they're bringing me to court, I said, okay, well, let's go to court then. So I agreed and waited for them to bring me to court, and here we are. They wouldn't give me my amount that I needed records of. I kept on asking and asking, never got it. Now they have it at court. I just believe that due to the stress, defamation, and harassment that I've repeatedly gotten from them, moving people into the house and forcefully moving me out and acting like I moved on my own accord is completely fabricated. They know this Benji guy. They've made this move all on their own. I had nothing. I didn't know this guy from Sam or Adam until he was already in the house and had access to it. I did change all the locks because there was tweaker people coming in my house when I was at work that they had continued to let stay there. I told them that I'm afraid because she was walking around with a knife and screaming in the middle of the night, breaking my sleep. But this was somebody that they knew and cared about. They wanted her there to get sober and just give her a chance to get sober. And all this is in text messages that I really wanted to subpoena my cell phone records for, so that I could show this to the court and make a fair and just ruling. But if we don't have time for that, then it's just my word against theirs and paperwork that's been printed up. Beyond that, all I have to say is for the amount of neglect this property has received, and the amount of defamation to my character due to all the neighbors and everybody around, that they would go knocking door to door talking about me badly and harassing me repeatedly at work, and just blowing me up when I told them that I would get a hold of them when I had money but they kept on going and going every day. Like, I was like, what do you want me to do? Rob a bank? Like, I'll get you the money when I have it. And it just got to a point where I had to block them. And I told them, I'm moving out. I have damaged properties. I took my time to move all my things as soon as he was coming in and cleaning the place. Unannounced. I had no idea who this character was, but they're outside meeting with him, taking a payment and making agreements with him when I didn't agree to him being there. So I just decided to leave, Your Honor. I don't know this guy. I don't know who he is. I don't know if he's going to steal my stuff or destroy it any more than they already had. So I took my things, I put them into a storage unit, and now I'm living out of my car until I can get the money up to get my own place again. I just didn't want them to do anything more. But yeah, the reason that I did change the locks, Your Honor, and I did change the locks, and they did have access to the key, which is also in cell phone records. I left the copy of the key next door to a person that they also knew for their entire life. She actually helped born her when she was a nurse, supposedly. So my next door neighbor had the key. They're a trusted individual between both parties. She had a key to my house. She knew that. It's not that I wouldn't give her a key or unlock the door. That's all bullcrap. They had full access to my house. The only reason that I wasn't there was because I was at work, and I told them where the key was. So all of this stuff is completely fabricated. They're trying to make me look bad. I get it. But in no way, shape, or form is that true. They always had access to the house. I only changed the locks because I was afraid that bad characters had access to my house, because supposedly these two other people that I moved in, one was a drunk and one was on meth, they had lost the keys. As soon as I made them copies, they lost them. So I changed the locks. And I let the landlords know that that's why I changed the locks. It's not to force them out. That's illegal. I let them have a copy. It was right next door anytime they needed to access my house when I wasn't there. So that's all fabricated, Your Honor. Anyway, that's all I have to say. If they don't want to make mediation, that's fine. I was willing to go that route, but they want to go this route. And I really would like a continuation so I could get these records to prove that they're lying.
Okay, so
Your Honor.
just a minute, ma'am. So the issue there, Mr. Arneson, this is, you talked about a lot of things, but really what this case comes down to is whether or not the rent and utilities were paid or not. That's it. And all this other stuff about changing the locks and, who moved who in, that's not really, relevant or germane to what the issue is. And early on, you didn't seem to dispute that, a lot of the stuff that you were required to pay didn't get paid. And it's been well documented by them that I'm looking here right now, that and they mark each, they go by month on what was supposed to have been paid, what was actually paid, and what was left unpaid. And there doesn't seem to be any real dispute about that. And so based on all of that, based on the documentation that they've presented, I am going to find in their favor. Did you get a service fee? I didn't see one on there. Did you have to pay someone to get him served?
I did, but because I was at the limit, I didn't know if that could be added on or not, Your Honor.
Is there a receipt for that? And how much was it?
I don't have one, and that's actually not even a concern at this time for us, sir.
So a judgment's going to enter in the amount of $10,000, and then there'll be a $50 filing fee, and the total amount is $10,050. And again, I want to be clear, that's for unpaid rent and unpaid utilities, basically. And that's going to be my decision in this case. And you can get a copy. You can get a copy of it right now since you're here. And Mr. Arneson, you can get a copy of it off the district court website. And there's nothing to stop you from entering some sort of agreement to make payments on that. Otherwise, it'll be, their responsibility, as I said before. I mean, it's just a judgment entered, and that's it.
Right.
So you're free to go, Mr. Arneson. We'll give you a copy of that. Once you get that, you're free to go.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Peninsula Place versus Jamar Pye. Uh-oh. Bottle got him quiet, and then I call you, right? All right, state your name.
Joe Morbo.
Thank you. All right, where are we with his?
To keep cheating me by bringing the baby in. He's at 1,017.36.
1,017.36.
Which means he's paid a little over 500.
From the last time that we were here, right?
Yeah, he was supposed to pay 1,000, but he did pay.
Well, no, I had a.
Oh no, I'm sorry, that's the next one.
Yeah, no, he wasn't going to pay 1,000. He was going to pay. He was actually going to pay 400, but paid more than.
Yeah, I paid 530 and paid an extra 100 the other day. So I'm at like 900 right now, but the last 100 is pending, like right now.
You paid something yesterday?
Yes.
On Christmas?
Yeah.
Yeah, I don't have that.
Okay, so okay, I got you. No, that's fine. You don't have to show it. I believe you because you paid more than what you. Reason I don't need to say you told me that you were going to pay 4, but you've actually paid more than what you told me you were going to pay.
Right.
Okay, so how are you going to get this last part paid out?
Well, rent coming up, so I'm going to pay rent, and then.
Well, hold on. Don't. I hear what you're saying, but I don't want to look at it that way right now.
Right.
How would you get this 1,017 paid?
Really basically paying it. I was gonna try to pay it all off through January. That's what I was planning to do. Because it's only
that and January?
Yeah, and January rent. So upcoming rent, and then before February rent come, it should be all the way down.
Okay, so all right. I got to work with certain accounting principles as to how we're doing this, okay? So how much is your monthly rent?
Around like $658 just rent by itself.
All right, so let me ask you this. When's the next payment you can make?
It'll be after the first, so probably.
No, that's okay. I just needed you to tell me when you can do it.
Well, I was doing 200 a week, so.
You're doing 200 a week is what you want to do.
Yeah.
So what day do you get paid? I mean, what day of the week were you going to try to make that 200?
I want to say like the 5th.
The Monday?
Yeah. Well, I don't know exactly what day it is, but the 5th of January.
That's a Monday.
All right.
But that's when you want to pay the next 200 is what you're telling me. But here's the deal. If you pay 200 each week, then by the end, if you start on the 5th, by the end of January, you've only paid $800, which is really effectively going to be just basically your January rent cost. Right. But then you're still going to owe this $900 now.
Right.
You follow me?
Yeah, but I was saying I was going to pay rent too, like paying rent too.
Right, but so here's what I'm trying to do, like with everybody else. I'm trying to work out how you're going to do this so I can give you more time to get it done. Okay. Because right now, if I give this judgment, you got to come up with that basically 1,000 according to their records, but 900 according to yours. You'd have to come up with that by the 5th.
Okay, no.
So what I'm trying to do is I'm trying to figure out how to kind of spread it out for you, but I got to make sure for the landlord that everything's going to get paid.
Okay, right.
So when are you going to pay, since you want to work it that way, we'll try it. When are you going to pay your January rent?
Around the same time I was going to pay that extra 200. So
around the 5th?
Yeah.
Okay.
So you're going to pay like 900 on the 5th total?
Right. And that's
your rent's 729.
Yeah.
And how much did you pay yesterday?
I paid 100 yesterday.
729, and then you're going to pay So we might be able to do this, do it
Right.
just as straight. Okay.
Yeah.
So you
Well, let's
got
make it-
900 basically that you got to pay, right?
Right. Yeah.
So we're going to make this real simple. I'm going to
Closer
grant.
to 8, Your Honor.
Pardon?
It's closer to 8. The rent's 729, and he's got, the utilities are pretty small there because they're split with the other folks in the apartment. But his January rent is going to be just under 800.
800.
And he owes
So-
1,017.36, make it 917.36. So that's why I say his rent's going to be a total of 8.
So he needs the additional 200, which will bring him about 1,000 and do whatever. Okay.
Yeah.
Let me ask you this, young man. Again, just trying to make it simple. By that date, the 5th,
Mhm.
do you think you can come up with $1,000? Well, no. How much would he have to come up with? Let's see. You got me confused.
He says if he paid 100 yesterday,
he's
he
at.
owes 917.36.
Right. So $900.
So can you pay that 917.36 by the 5th? Or if I gave you to the 7th, can you get that paid?
Can we go to the 10th, or am I pushing it?
What about the 9th?
9th, cool. We can do the 9th.
Yes, sir.
Done.
No, that's fine. Okay, so what I'm gonna do, I'm gonna grant a judgment for possession for that total amount of the 917.56. That's only because they don't have the 100 right now. Okay?
Right.
But they'll
But it's changing.
subtract that out.
Yeah.
All right. And then I'll give you until the 9th.
All right, so if it's all paid, I'll have to come back here on the
You don't have to come back. The baby does, you don't know. But no, you don't have to come back on that, but understand that what we just ordered here, that doesn't include your January rent.
Right.
Even though you're paying the January, you gotta then get your January rent paid.
That's cool.
Got it?
Yep.
Okay, that'll work.
Appreciate it.
All right, not a problem. Take care. Peninsula Place versus Equities Gardner. Should have just called them up at the same time. Why not? Then they just switch the baby, bring the baby.
How they're doing it.
They got it all under
They
control.
know.
They realized that I like both of them, but I'd rather just see the baby.
She's at 1999.61.
1999.61. All right. And Ms. Gardner, how are you gonna get that? Now,
I couldn't.
you said you paid 1,000.
I couldn't pay it. My car broke down.
Your what?
My car broke down.
Okay.
In the middle of the street. But I have half of the 1,000 from January 2nd right now that I can.
Say again.
I was gonna pay another 1,000 on January 2nd. I have half of it now if you want me to pay.
Half of. You have 1,000?
She has 500 right now.
From my check that's coming next week.
Okay.
You want me to pay it before the 2nd, then I can pay
And
the
then the 2nd, you'll have how much?
500.
So you'll have 1,000 by the 2nd. Gotcha.
You have the other 1,000.
The 16th,
The 15th?
the 16th, 2 weeks from the 2nd.
By the 15th,
16th.
16th, that Friday. Gotcha. Okay. Okay. Ms. Gardner, here's what I'm gonna do, because this is gonna be I'm gonna do the same thing. I'm gonna lock you in at this point so that we're not dealing. How much is your January rent?
635 before adding.
Okay. Then I'm not gonna worry about your January at this point. Here's what I'm gonna give you time to get this done.
Mhm.
So what I'm gonna do is I'm gonna grant it for possession to the landlord for the 1999.61. Defendant to pay $1,000 January 2nd, 2026. Getting paid balance by January 16th, 2026. You don't pay that 1,000 by the 2nd, then what's going to happen is they're going to be entitled to a writ on the 5th.
Okay.
Got it?
Mhm.
You think you can do that?
Yeah, I'm gonna pay.
Why are you looking at me like that, Miss? Didn't I?
Me?
Yeah. Are you just looking at me funny? Are you mad at me?
No, I forgot to check the money judgment box on Mr. Pye's judgment. I was waiting for a chance to tell you that I would request that you check the money box on that.
Oh, on that. Okay. We'll do that. Then I'll grant a judgment
The
to
guilty
the
plea
plaintiff
where
in
no
this
man
case
pursueth
for possession and money. All right, you'll get everything paid by the 16th,
Yes.
right? And now that we resolve both of your cases, the little guy, I don't get to see him anymore. I almost want to just set another date for one of the two of you, make you bring the baby. All right. You guys take care of yourselves. Take care of that little one. All right. Glenko Hills versus Ali Hicks. Hello.
Hello, how are you?
I'm doing good. Your name?
Ollie Renee Hicks.
All right. And where are we with? Well, this was a judgment taken.
But you've already issued a judgment and an order of eviction. It's scheduled for the 8th. She, with the help of Ms. Bauer, has had her voucher reinstated by RPI, and they have not sent official notification yet.
So
see, the documentation from our RPI will reduce her to $896.69.
That she would owe on that?
That she would owe, and otherwise it would be, yeah, so that's what we have is $896.69 that she will still owe, which I think she's responsible to pay.
Okay, what do you want to say, man?
I spoke with an attorney from Legal Services,
Okay.
and he stated to me that there is a possibility that my portion to pay may be zero because I was cut off of Social Security in July. So there may be a chance that it will be zero, but I have to wait to find out. I'm not for sure, but he said that there is a possibility. But also, in addition to that, I have an appointment with Hawk the first week of January, and they are working together with Senior Services to get the rent paid. I believe the name of the group is Senior Services of Washtenaw County.
If I could have just a moment, Your Honor, I did get an email from Mr. Campbell. Let's see. That's not helpful, but let's see. Housing Bureau, Ms. Linton is involved. And so they are reversing the current termination, but there's still some gazintas to do about some employment that Ms. Hicks has had. So as of right now, it looks like my client used the best case scenario for what we know, which is that she owes $896 will be her portion, $896.69.
Okay. But she has two
instead of 5,300 or something
right,
like that.
Exactly. So it seems to me that what I will do is I think I'm inclined to adjourn this to the 16th. I want to see what the agency says, whether or not there's assistance there that would at least pay that off. There may have to be some calculation. but also if your rent should have been 0, it may give them time to figure that out, which might reduce that. Now it might go up because there's some other issues involved. I get that, but at least yes, ma'am.
I spoke with Mr. Campbell last night, and there was a job I had, and that job was, I took the position because I was cut off with Social Security, and I stated to him that that was after I was, the voucher had been terminated, which was September, so that employment will not impact what I owe.
Okay. Well, we'll sort that out.
Yes.
I'm more worried about the fact that if there's assistance out there that will cover that, then we can cover it. But also then if it was supposed to be 0, then maybe that's going to take away from some of that. That's really what concerns me. But what the good thing is that the big chunk of it.
Yeah.
All right. So
I want to do my
Have you issued the order of eviction, Your Honor? I see that we submitted one, and my client told me it was scheduled for the 8th, but I don't have a signed copy in front of me.
You see the writ on this?
I just want to make sure that nobody
on the 11th,
the 8th, to move her out when she's expecting to come to court on the. Did you say the
16th? So what I'm going to do is I'm going to stay the writ at this point, or stay the execution of the writ. And then I'll adjourn this to January 16th, 2026 at 2 p.m. Okay. And then maybe we can have the news either on the assistance or the other thing. Sound good?
That'll work.
Okay. All right.
Wonderful.
Thank you. Have a blessed meeting. Real Properties versus Courtney Gough.
And Carl on behalf of Beal Properties.
Hello, what's your name?
Courtney Gough.
All right. And where are we on this?
Well, Judge, I'm at a little bit of a disadvantage. We never got this motion. We tried to confirm with the court that it was sent to us. We just never received it. So I've been scrambling since about 11 o'clock this morning to know where I'm at. If I'm reading things correctly, I think the motion to set aside the default is untimely. And furthermore, the defendant's already been evicted.
I was locked out.
I have an application order of eviction that I believe Your Honor has signed.
Oh. Ma'am, you're saying, all right, so here's part of the problem, counsel. She's saying that she had paid her balance in full on the 6th of November.
I had paid it for October, and when I got served, I was told that that's what I had to pay to not come to court. So I obviously should have come to court in hindsight, but I didn't because I paid it on the 6th.
Okay. All right. So you paid what on the 6th?
So I paid October's rent.
On November 6th?
Yes.
Got that. And I see the proof of the payment of that. We got it. And how much was your monthly rent?
$9.90, but it ended up somehow every month being $10.50. I think with late fees, it was $10.50.
Do you have anything regarding their balance currently?
I don't have anything regarding the balance. What I have submitted to your honor are the court orders for the default judgment as well as the order.
I see all that.
That's all I have, because we did not know about this motion until we pulled a copy of the court's docket late this morning. So we did not because we did not receive it. I don't have a ledger. All I have, we were able to pull those.
Right, I got all that, but I guess I'll tell you what part of my problem is. That on the 6th of November, and I have proof the basis she's provided, there was a debit card payment of $530, which I'm presuming from your perspective, Ms. Gough, that brought you through October.
Mhm.
And that's, you're saying what they told you had to pay, right?
Yes.
Okay, and counsel, where I have a problem and I realize a certain disadvantage, but just looking at these numbers, and part of this assumes that what she's indicating to me is correct, but I'm looking at the complaint. And at the end of October, about $1,000 was owing, which was her October amount, right? I have then a payment for $530 on the 6th. Then have a judgment. And then I have a judgment, $1,705. Part of that's court cost, right? But the principal, I don't know what happened here, but I'm just going to say this. I'm having a tendency to lend some credibility toward what Ms. Gough is saying. And here's the reason why I'm saying that. Is because the principal amount of the judgment, absent court costs, is exactly what she paid less $1,000, which was really her November rent.
If I may hazard a guess, Judge.
Yeah.
My guess is that Ms. Gough was told, and it's purely speculation on my part, that she was told sometime in October, if you pay this amount, you'll be fine. She didn't pay that amount until November. As we are wont to do, we submit an order on the date of the hearing that includes that month's rent as well. So while she may very well have, had she paid that amount in October, been current, or our client would have taken notice of that, by the time we got before your honor, now November has come due, and that's what was submitted. I'm guessing.
I got you. When did they tell you to pay the $530? To pay up through October?
They said as long as it's paid before the 7th, you don't have to show up to court. So I really should have shown up, but
No, but when they say, as long as it's paid, are they talking about the full amount or just October?
Just October.
Did they tell you that specifically?
They said with what is on this paperwork, as long as this is paid, the process server.
When you say on what paperwork?
On the initial eviction paperwork.
Okay.
So it was.
You just mentioned something. Was that the process server that told you that, or somebody?
It was a process server. Yes.
Oh, dear God, Lord have mercy.
And your honor, I would submit that that's not my client, and my client would not have given
that. Counsel, I'm not stupid. So somebody told you that, right? Did they remove all of her items from the unit?
I'm sorry, what?
Did they removed everything from her unit?
I don't know. All I know is that she's been locked out. If you'd like to pass this, I can find out from my client. Assuming they're working today.
What? So where are you staying right now, Ms. Gough?
Unfortunately, the Harmony House.
Let me pass it a minute. Let them find out. Okay.
Thank you, Judge.
Court recalls cases, BO versus Gough.
Again, Your Honor, Jim McCarnell on behalf of BO Properties.
Your name, ma'am?
Courtney Gough.
All right.
Your Honor, I called several different phone numbers and either they're not in today or they're all busy. But I called about 3 different numbers and no one picked up. I have left messages, so I don't have anything to report to the court.
Here's going to be the problem, ma'am. The judgment was entered. Ma'am, did you ever pay your November rent?
I didn't.
Huh?
No, I didn't.
Okay, let me ask you, why not?
I got really sick and I had to take like 2 or 3 weeks off of work, and in my line of work, you don't get paid for that. So that's
Okay, so let me ask this then. Is it the same thing for your December rent?
well, also my work it fluctuates. My income fluctuates very often, but it's been very slow for the past like 2 months. So that has been something that I've never dealt with. I've never not been able to pay my rent, like literally. So I don't know. It seems to be picking up now. So
Okay, no, I got you. There's a reason why I'm asking, because I'd probably do one thing if somebody told you that, and I believe that somebody told you that. You paid it, and then this happens, but you also then had paid your November rent.
right, I understand that.
Right. But this looks like a much different circumstance because, and I have to just kind of go with the equities of it. Had you come to court on the 7th, okay, we may have gotten an adjournment, but we would have still been in November. And then what would have ended up happening we would have seen the payment, right? But then November wasn't paid. So they would have gotten a judgment that you would have had to pay November. And then even if they didn't get the judgment regarding November and it kicks into December, you'd still have to pay both of those. Got it?
Yeah.
So while I understand the motion and why you may have acted the way that you did, and that it's quite frankly nobody in this room's fault, I don't know that the equities of it would lead me to the conclusion to say the plaintiff restore her back because she then paid November, she did whatever. It's like part of it was done, but the other part wasn't, and we would end up in the same spot.
So what about my things?
Well, and that's an interesting thing. You can go talk to your landlord about it, but typically, ma'am, regrettably, when my order's being executed, your items that are there are removed from the premises. In fact, they have to be before the premises are indeed locked. While I don't know for sure, the email from the court officer indicates that that's what transpired. Your things were removed and the premises locked. Okay, sorry. All right.
It's not your fault.
No. All right. So for those reasons and for the reasons stated, I'm regrettably going to have to deny your motion.
Okay.
All right, the judgment and eviction was.
You need an order, Your Honor?
All right, thank you. Same to you, ma'am.
Your Honor, I hope you and your staff have a safe and happy New Year.
You do the same, sir. Zang Fang Zang versus Kelly Rudick.
Good afternoon, Your Honor. Andrew Cates, P7292 for Mr. Zhang.
Right. Hi, Your Honor. I'm Kelly Radock.
Okay. Where are we on this?
Your Honor, the firm has sent out the signed demand letter that was missing as of the last hearing. However, we haven't been able to file a proof of service because Mr. Rick not receipt of it at this moment. And that was basically the extent of the discussions we had. You acknowledge that there is still a case with a rather substantial amount of rent due, and there is a question of water bill.
Well, this is saying that it was sent November 13th, 2025. And ma'am, you're saying you didn't get this.
Correct. That's correct, Your Honor.
Okay, just skipping ahead before I can even begin to resolve that. Are you disputing the amount of rent that's owed?
No, Your Honor, but the water bill amount that I was told today is not what I believe to be the correct amount. I don't know if that's.
How much is the water bill?
Your Honor, I was told that there is an outstanding water bill of $1,720.91.
Okay. Hey, ma'am, I guess here's I guess the bottom line reality to all this. Let's assume for the sake of argument they cannot provide an adequate proof of service from the court's perspective, right? And they send out another demand to pay. The reality is you can't pay that. Is that right?
Today I can't pay that. I was going to try and attempt to pay the full balance through like borrowing through friends or my network or family, whatever. But not today. I don't have the money to pay that.
Are you anticipating having the amount soon? I mean, because I was looking at almost 25,000.
Right. I'm not anticipating it, but I was going to attempt to try and borrow it if I could. So no, I guess I don't have the ability today to pay it, and my income doesn't support that much per month to pay it off in like a certain amount of time, like 30 days or something.
Let me just do my math here. Let's say they send you a notice today. So basically, you get you most of the night. You get here, you get an adjournment, blah, 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 16. So, maybe, are you anticipating having this, say, by the end of January? I mean, I guess I'm not clear what you're telling me.
No, Your Honor, I don't at this point. No, I would say no, but like I said, I would attempt to try and borrow it from multiple places if necessary, but I guess that's hopeful, but I don't have solid.
So what would you want me to do today?
I mean, if the ability to allow me time to move out of the house would be what I would respectfully request. I am trying to move.
That's fair.
Sorry.
Go ahead.
I'm just, it's like a 4 or 5 bedroom house that I'm trying to move out of that I've lived in for 6 years. And I have I have an 8-year-old at home that I have to manage around all that. So time would be what I would hope to get, I guess, to move out.
You talked to the other side about time to move?
I tried to talk to the this gentleman I just met today, or he came in today. But the attorney's office, I called and asked them about it previously, and they said they couldn't talk to me and they couldn't talk to my landlord, but I had to contact my landlord, who I never heard from when I like reached out and I never heard back from her. But so I haven't talked to them about taking time. I don't know why they said that, but they were.
Okay. So you have an 8-year-old.
Mm-hmm.
It's all right.
Sorry.
It's okay.
I'm like nervous.
Pardon?
I'm nervous. Thank you.
He's in school right now, or will be.
Yeah, he's on break right now.
So if you move, you know where you're going.
Not yet. I'm trying to secure housing for us to move to. I mean, I can move things to storage, like a storage unit that are like major things, but I'm trying to secure housing. I'm like working on that.
Okay, let me ask you this. This is, rent is what, 33 something a month?
3,200 a month.
How'd you get yourself to this point? What happened?
There were some significant things that happened over the summer with, first, my income was like significantly reduced. I was involved in a domestic violence as a victim, and there was, I became a single parent. So it's just, I've been trying to get past these hurdles, and it's just put me really far behind. Sorry.
No, don't apologize. So are you, the domestic violence circumstance, and I'm asking for a reason, not just to pry into your life, okay? Did that involve the father of the 8-year-old?
Yes, Your Honor.
So let me ask you the next question. Are you getting support?
Yes, solely, but yes, I have family, like a friend.
No.
Oh.
Hold on. I probably should.
Sorry.
I asked the question inartfully. Are you getting child support?
No, I'm not, Your Honor.
Have you sought trying to?
Not yet. I don't think he'd be able to pay child support either, but I haven't attempted to like seek child support. I don't know how he can give it if he yet doesn't have it, but I understand, like, I haven't.
Why is he not working? Is that your deal? Is that
Correct. Yeah, he doesn't work frequently. It's like sporadic. It's not like an employer he goes to.
All right. Let me ask you this.
Sorry?
If you were to give us your email and name, do you have a problem with us turning that over to the front of the court and let them try and figure out if that's the case?
To who?
The front of the court.
I don't know. You mean have them contact me?
Well, they would contact you, and they would also be looking as to whether or not this individual can pay.
Gotcha.
And what they can pay.
Gotcha. I don't know. I'm not sure.
Do you have a problem with us doing that?
No, I don't think so.
Okay.
I don't, sorry.
It's one of the programs that we offer here.
Okay.
For individuals that, I guess all too frequently may find themselves in the position that you're in right now, where all of a sudden you're trying to figure out how you're going to manage everything.
Mm-hmm.
Right? And so one of the things is that people have their obligations. And so we've been working with the friend of the court to try to make sure that that happens, so you're not in that circumstance. All right. So that happened, your hours get reduced at work, and then you're trying to hold it together, just
That's true. Sorry.
maintain and have an 8-year-old that's looking at you, and you're trying to get, although you're worried as all get out, you're trying to make sure that this little one doesn't worry.
Mm-hmm. That's true. That's correct.
Oh?
Yes, you're correct. Hard.
I got it.
Oh, sorry.
Counsel, are you aware as to whether or not without yet ruling on this other issue, whether or not they would give her time to get herself situated. I mean, they probably don't know all of this. You're just here.
I would highly doubt that they know any of this right now, Your Honor. To be honest, my authority was to basically get a consent judgment with the standard 10 days. But if you were to.
But that does no good because if I don't sign it.
What's that?
No, go ahead.
Well, I mean, and we were well aware of the issue with the demand letter. So, I mean, in the contingency of that, they were asking me to either ask for an adjournment to get her served with the demand letter, or, you know, if Your Honor was saying we'd have to refile the case, we would do that. So it really all came down to this demand letter issue.
Right. Here's what I'd like to see. All right, what I'm going to do. I'm going to adjourn this out to my next date of January 9th. Allow you to try to give first class mail to her. Okay, of that. And then I'll rule on that as to whether or not that would correct it. In the meantime, counsel, I'd like for you at least to take some of this information back to your client, see if we can give this mom some breathing room a little.
Understood, Your Honor.
All right. Ma'am, will that, it doesn't solve anything necessarily, but at least.
Thank you, Your Honor. I appreciate that. I'm sorry.
You know what?
Thank you.
Quit apologizing. Okay. You're effectively right now a single mom trying to run around and trying to figure out an 8-year-old's brain, and you're trying to hold everything together, and then you got to find a place for you and your little one. Right?
That's right.
All right. I would normally set this on. I'm going to go to the 16th on this one, January 16th, 2026 at, that's at 12 noon.
Thank you, Your Honor.
Now, ma'am, I normally would have, I could have set it on the 9th. I'm setting it on the 16th. I'm setting it on the 16th for, I'm giving that additional week for a reason.
Thank you, Your Honor.
Okay. And well, here's my reason for doing that. I would imagine that you're probably not sleeping. You're not, probably not eating like you should.
Not healthy, right?
And you're just scrambling.
Mm-hmm.
All right. So here's what I'm going to do. If you want me to make it in order, I'll write it up right now. Because you probably haven't taken time for yourself. So I'm giving that additional week, and I'll say it's over the objection of plaintiff, but I want you to take this week. Okay? Relax. I want you to think about you, or even just a little bit. Okay? This will all be here.
Okay. Thank you.
Just think about you. All right?
Yeah.
Can you do that?
I will try to do that.
No. No.
Yes,
Can
Your
you
Honor.
do it?
Yes, Your Honor.
Because if I got the draft in order, they're not going to be happy because they're the ones that are going to have to type it.
No,
But
I can do that, Your Honor. Thank you. I appreciate it.
you're welcome. And do me a favor.
Mhm.
Relax that week. Go home and realize what's really important in life and give that 8-year-old a big hug. Fair enough?
Yes. Thank you.
Have a good New Year. See you on the 16th.
Thank you.
Ma'am, if what you do is my coordinator will take care of you, get your email address so we can send that off to FOC for you.
Okay.
Okay?
Right. Wait over here.
Yeah. Sile Farms versus Maria M. Lotha.
City Fontanilla for the plaintiff, Your Honor.
Yes, she is. Sinlotha, hello. Oh, you're muted. Oh, where'd she go? Oh, there she is. Bless her heart. Can you get it?
Unmuted.
Oh, you got it.
I got it. He kept
Got
going
it.
somewhere else.
Okay.
Sorry about that.
Alrighty. Was anything able to be paid between the last time we were here?
Yes, Your Honor.
Okay.
Oh, sorry.
Hold on, Miss Inlotha. What do we have?
Your Honor, I'm showing now that there's rent of $90.71, court costs of $190 for a total of $280.71. My understanding is that Faith in Action had come through and made a payment on the account.
Miss Inlotha?
Yes.
The 280.71. Are you going to be able to get that paid or?
Yes, I should be able to come up with that amount next week, Friday.
By when? Friday?
By Friday next week.
By the 2nd. Okay. So here's what I'm going to do.
It may be sooner than that, but I just don't like to make promises I can't keep. So
Yes,
I know
ma'am.
I know Friday I will be able to.
I
But if I
gotcha.
can come up with it before, I may pay before Friday, but to be sure, Friday.
Okay. So here's what I'm going to do. I'm going to grant no tribal issue judgment to the plaintiff for that full amount of the 280.71. All right. With a writ date of the 5th. Okay, I'm doing that to freeze that number. I don't want it to go over into January, Miss Lotha. And
Yes,
what I'm
and,
going to give plaintiff permission to do is, if you submit the judgment after the 2nd, I will just sign it. Otherwise, if it's paid, then you can dismiss it.
And the judge, I wanted to ask, did they charge me for December late fees? Because I paid
Pardon?
1,000 for December rent.
Well, but if you're Miss Imlota, if your account's behind, that's going to be a problem, okay?
Oh, okay.
They're entitled to their late fees if your account's behind.
Okay.
All right. All right. So we'll do it that way. And Miss Imlota, my last case of a very long day, and that makes me happy that somebody came through and we got most of this done.
Yes, I didn't enjoy Christmas. I wish the check came before Christmas.
Okay. All right, Miss Imlota, you take care of yourself. Okay.
Yes, thank you so much. And this is a good birthday gift, and God bless you.
All right. God bless you too, Miss Imlota, and have a blessed new year, ma'am.
Thank you, and same to you all.
And may God bless us, everyone. Ladies and gentlemen, thank you so much for hanging out with us this evening. It's been a great pleasure presenting these few cases from December the 26th, the day after Christmas. It's Boxing Day, ladies and gentlemen. If you don't know what that means, you'll have to go look it up because I barely know what it means myself. But I know it doesn't mean what you think it might mean. Ladies and gentlemen, it's been a pleasure. Have a great night. I am your humble lone wolf Usul. I am your presenter for these here videos, your curator for this here channel. And ladies and gentlemen, there will be more. As a matter of fact, in about 13-ish hours, there will be a little bit more. So keep an eye out. And if you're not subscribed, make sure you are. Make sure those notifications are on. And I'll be back tomorrow with some things. We're either going to watch a really long motion to recuse, or we're going to watch some other stuff. And I just haven't made up my mind yet. But it will be happening at noon Eastern time. That's 11 a.m. Central time. And we'll be having brunch right here in my living room. And we'll be watching court together, and we'll be chatting about it over the chat somewhere. Guys, I really appreciate you. Rhonda, thank you for being here. Mama, thank you for watching out for things. Shiloh, great to see you. Amy, Marty, Akival, Romiticus, Mary Beth, everybody on screen, everybody off screen, all the lurkers, all y'all folks. Thank you so very much. We'll see you next time. I am your Lone Wolf Usul, and I am out. Thank you, Becky. I'll be looking for you. See you next time. Yeah. I promise. No silly Ferris Bueller bits. Not tonight. Oops.